Judgment in the matter of THG against Zedra Trust Company.
Lord Richards will hand down the judgment.
The principal issue on this appeal is whether there is a limitation period applicable to unfair prejudice petitions under the Companies Act 2006. This simply stated and apparently narrow question has implications for a wider range of statutory actions and has required the Court to delve into a wide range of decided cases, both in this country and other countries with a common law system, and into English legal history. Sections 994 to 996 of the Companies Act enables shareholders and other members of a company to apply to the Court for relief where it is alleged that the affairs of the company are being or have been conducted in a manner which is unfairly prejudicial to some part of the members, including the applicant. For the purposes of the present appeal, there are two important features of these sections. First, they do not create any obligations. Instead, they enable the Court to make orders to remedy a past or present state of affairs. Secondly, the Court has the broadest possible discretion as to the orders, if any, it may choose to make. The Court is not bound by the orders that an applicant may ask for in its petition. A limitation period is the period during which a claimant is entitled to bring a claim. A claim is time-barred if brought after the end of that period and is liable generally to be struck out on that basis alone. Limitation is governed entirely by statute. The Companies Act does not lay down any limitation period for unfair prejudice petitions. The issue is therefore whether any limitation period is provided by the Limitation Act 1980. The Limitation Act provides limitation periods for many, but not all, types of claims. It is common ground on this appeal that the only sections of the Act which might apply to unfair prejudice petitions are Sections 8 and Section 9. Section 8 provides a 12-year period in the case of what is called an action upon a specialty. This somewhat archaic phrase covers actions to enforce deeds and other instruments under seal, including, at least in some cases, statutes. Section 9 provides a 6-year period for, quote, an action to recover any sum recoverable by virtue of any enactment, unquote. In the present case, the appellant, Zedra Trust Company, Jersey Limited, had a substantial shareholding in the Respondent company, THG Plc. In 2019, Zedra presented a petition alleging unfair prejudice in the conduct of the affairs of THG. In 2022, Zedra applied for permission to amend its petition to include a claim for compensation for loss it said it had suffered as a result of being excluded from a bonus issue of shares made by THG more than 6 years earlier in 2016. THG opposed the application on the grounds that the new claim was time-barred under Section 9 of the Limitation Act. There was a substantial body of first instance decisions and appellate comments, as well as statements in textbooks and Law Commission reports, that no limitation period applied to unfair prejudice petitions. Applying that generally understood position, the High Court held that no limitation period applied and allowed the amendment to be made. The Court of Appeal unanimously held that both Sections 8 and 9 applied to unfair prejudice petitions and allowed THG's appeal. On appeal by Zedra, this Court, by a majority of 4-1, reverses the decision of the Court of Appeal and holds that no limitation period applies to unfair prejudice petitions. Lord Hodge and I give the majority judgment, with which Lord Lloyd-Jones and Lord Briggs agree, and Lord Burrows gives a dissenting judgment. As regards the application of Section 8 of the Limitation Act, the linchpin of the Court of Appeal's decision is the judgment given by the Court of Appeal in 1984 in a case called Colin and the Duke of Westminster. In that case, the Court of Appeal expressed the view that Section 8 applied to a claim to enforce a statutory right by a lessee to the transfer of the freehold title to a property. In subsequent decisions of the High Court and the Court of Appeal, the view expressed in Colin has been understood to mean that any claim based on a statute is subject to Section 8. That was the approach adopted by the Court of Appeal in the present case. The majority in this court consider that this is a misreading of the judgment in Colin, which, properly understood, was confined to the enforcement of obligations created by a statute. The majority hold that Section 8 does not apply to a claim which, although based on a statute, does not involve the enforcement of any obligation created by the statute. As already noted, Sections 994 to 996 provide for remedies to rectify a state of affairs, but they are not remedies to enforce any obligations created by statute. Section 8 does not therefore apply. As regards Section 9, the Court of Appeal, applying earlier authority in the High Court and the Court of Appeal on other types of statutory claim, held that if a petition under Sections 994 to 996 sought a monetary remedy, such as the payment of compensation as in the present case, the 6-year limitation period under Section 9 applied to the claim for that remedy, although not to claims for other remedies made in the petition. The majority in this court hold that Section 9 does not apply to cases in which the court has a discretion as to the type of remedy which it will award. It does not therefore apply to petitions under Sections 994 to 996, where the court has a very broad discretion as to what, if any, orders it will make to remedy the situation. For these reasons, which are fully explained in the majority judgment, this court allows Zedra's appeal. Lord Burrows, in his dissenting judgment, expresses the view that as a statute is a specialty, any claim made under a statute is an action upon a specialty to which Section 8 applies. As regards Section 9, he considers that the Court of Appeal was right in this and earlier cases to apply it to a claim for any monetary remedy, irrespective of the breadth of the court's discretion as to the orders, if any, which it may think fit to make. Given the public interest in preventing stale claims, he considers that Sections 8 and 9 should, if possible, be given a purposive interpretation so as to apply to unfair prejudice petitions.